Hi, it's Maddie, and today we're going to be talking about DNA and due process within the criminal justice system regarding a specific case in the Supreme Court called DA's Office v. Osborne. The availability of DNA testing to those suspected or convicted of crimes was kind of up in the air before the Supreme Court decision, which fully pushed the US into the DNA era, or the era in which DNA was regularly and actively used in the justice system, under specific pretenses. It was only in the 80s when states began passing laws that required the collection of DNA samples upon conviction of violent crimes, especially sexual assault. This evolved to the NDIS, or the National DNA Index System, being launched in 1998. The FBI had been working on it for years preceding that, so from my point of view, it is clear that once criminally convicted, you lose the right to the privacy of your own DNA. But most people have decided that this is a way to further protect the public. Kind of like a necessary evil. While it may seem like DNA tests should be a given if requested post-conviction in an attempt to prove innocence, it really isn't. It was the District Attorney's Office v. Osborne, beginning in 1994 when William Osborne was convicted of sexual assault and kidnapping in Alaska. After his conviction, Osborne requested the access to the same biological evidence that was used to convict him. So for some background information, there was a DNA test performed at the time of the conviction. The DNA test used at the time was pretty rudimentary compared to the DNA testing that we have now. It really only narrowed down the possibility of it being him. I read it was about 15% of all African American males would have matched that. At the time, there was RFLP testing, which would have more conclusively stated whether or not it was him. His attorney at the time decided not to do the test in fear of further incriminating him, because she thought that he was guilty. The DNA test that he wanted to try at that point was unavailable at the time of his trial, to prove it wasn't him and that he didn't commit the crime. The Anchorage, Alaska District Attorney's Office rejected him and denied access. Osborne took the next step and filed suit in the federal district, alleging that the DA's office denying his request was a violation of his 14th Amendment due process rights, because it prevented him from accessing potentially exculpatory evidence. The suit was quickly dismissed after it was requested by the DA's office. Osborne appealed the dismissal of the suit. The United States Court of Appeals reversed and remanded the case, meaning the previous ruling was undone. It stays on the record, but it was undone and sent back to the lower court to be reviewed further. The appellate court found that the lower court's judge made an error related to law or facts of the case. While on remand, the lower district court granted a summary judgment in favor of Osborne. A summary judgment is there pre-trial to try and resolve the issue before going to a full trial. This ruling meant Osborne was entitled to the judgment or trial as a matter of law. The district attorney's office argued in an appeal against summary judgment that Mr. Osborne needed to show that the disclosure of evidence would affirmatively prove he is probably innocent. They also argued that a confession given by Osborne post-conviction meant he shouldn't be allowed to pursue post-conviction relief. The Court of Appeals denied the appeal based on Osborne's limited due process rights, and both arguments given by the DA's office. Eventually, the fight of appeals were brought to the Supreme Court, which resulted in a 5-4 ruling stating that Osborne's constitutional rights were not violated. The Innocence Project believes that while this decision is disappointing and flawed, it will have limited impact. Osborne was a client of the Innocence Project. The organization offered to completely cover the cost of the DNA testing. During the entire debacle of years of judgments and appeals, and going back between courts, district, and circuit, the former FBI director William S. Sessions thought the justice system should intervene, writing, "Why should our criminal justice system be so afraid?" It's a pretty good question, but this ruling doesn't mean that no convict can ever access evidence post-conviction, but it does mean it is not easy. At this point, William Osborne is a convicted rapist. This video is not here to say whether or not he is guilty, but to make mention of the possibility of knowing in absolute whether or not he is guilty being denied by the state. The certainty of DNA is unparalleled in our or any justice system. As of now, 46 states have laws or regulations that both recognize the value of DNA evidence and the need for conditions on accessing the state's evidence. Cornell Law wrote, "While Osborne does not have a liberty interest in pursuing post-conviction relief granted by the state, the Ninth Circuit," which is a region of the U.S. given its own judicial district, but the Ninth Circuit erred in extending the Brady right disclosure to the post-conviction context. The Brady right refers to a different court case from Maryland called Maryland v. Brady, which requires prosecutors to disclose material or exculpatory information in the possession of the government to the defense. So the circuit court ruled the district court was wrongfully extending the pretrial right of Brady to post-conviction relief. For Brady to apply in this circumstance, the DA's office would have had to have withheld the DNA, or knowledge of DNA from Osborne or his defense. But we know that his defense had denied the opportunity to do DNA testing or further DNA testing, which is not the fault of Osborne. I side with the Innocence Project on this though. Maybe that one case or right does not apply, but denying an incarcerated individual the opportunity to definitively prove or disprove guilt almost seems like freeing a few at the expense of the state isn't worth it. The state shouldn't have to go through the trouble after winning and convincing a jury of guilt. That quote a video or so ago from Justice John G. Roberts seems ever applying in these circumstances. He said, "The dilemma is how to harness DNA's power to prove innocence without unnecessarily overthrowing the established system of criminal justice." As previously stated, this was a 5-4 decision, meaning it was a close decision, and 4 of the 9 Supreme Court justices at the time disagreed. As one of them, and on behalf of the others, Justice Stevens wrote the dissenting opinion as, "In sum, an individual's interest in his physical liberty is one of constitutional significance. That interest would be vindicated by proving post-conviction access to DNA evidence, as would the state's interest in ensuring that it punishes the true perpetrator of a crime. In this case, the state has suggested no countervailing interest that justifies its refusal to allow Osborne to test the evidence in its possession, and has not provided any other non-arbitrary explanation for its conduct. Consequently, I am left to conclude that the state's failure to provide Osborne access to the DNA evidence constitutes arbitrary action that offends basic principles of due process." So that's it. The state said, "You snooze, you lose," and the court agreed. Enough. The truth may never be definitively known. The result of this is, as bluntly put by Peter Newfield, is that it's questionable that some people in some states who are factually innocent will not get DNA testing and will languish in prison. Some of them will die in prison. The decision stands, and so does the truth of what Mr. Newfield said.